Good afternoon. Our founding charter begins with "We the people," words that launched not only a government, but a great hope. They are the first words of our Constitution, and yet they remain the most radical, most aspirational, and most unfinished. They remind us that democracy is not given, it's made, not by the powerful, but by the people. Made in moments when ordinary people spoke up, showed up, and stood together. Selma, 1965, was one of those moments. A turning point where individuals armed not with weapons but with will put their bodies on the line for basic rights: to be counted, to be heard, to belong. What happened on that bridge was more than a march. It was a moral declaration to push this country closer to its ideals. My father was there. He walked alongside others who, armed with nothing more than a prayer and song, summed up the courage to confront power with principle. They were met with dogs and batons, but they did not turn back because they believed what we still believe today: that we the people is not a phrase frozen in parchment. It is a living, breathing principle that asks something of each of us. We look back at Selma as a defining moment, but today we face our own Pettus Bridge. The form may be different, but the stakes are no less profound. Like Selma, we as people of conscience are being asked, what will we do with this moment? And in our time, just like in Selma, this moment requires courage. And that's why we're here. Good afternoon, and welcome to week 3 of the 2025 ACS National Convention Series, a 4-week journey of ideas, energy, and community, brought to you by the American Constitution Society. Hi, I'm Roscoe Jones, the Dean of the Drake University Law School and the proud chair of the American Constitution Society's National Board of Directors. It is a privilege to be with all of you, leaders and learners and change makers, all committed to the promise of our Constitution and making the possibilities of our democracy real. First, I want to extend my deepest thanks to our sponsors for making this series and so much of ACS's bold and necessary work possible. I'm especially grateful to our underwriter levels of sponsors: Leaf and Cabraser, Hyman Bernstein, Kirkland Ellis, and Paul Weiss. Your partnership fuels progress. And to the brilliant, tireless ACS staff, thank you for shaping this series and advancing our shared mission every day: to build a legal system that is more perfect and that works not only for the powerful, but for we the people, that defends the rule of law, protects civil rights, and brings us closer to the full promises of our democracy for everyone: for people of color, for women, for the LGBTQ community, for peoples with disabilities, and for all historically marginalized voices. If you haven't joined this movement, there is still time. Become a member, donate, get involved. Go to acslaw.org. We need your voice and your courage now more than ever. As one of my heroes, my former law professor Pamela Karlan, once said, sitting on the fence is not practice for standing up. So get involved. As chair of ACS's board and as a law school dean, I see every day how vital this work is. We are living through a moment that will define a generation. Our shared commitment to a multiracial, inclusive, democratic society is being tested in ways few of us imagined. And yet, in the face of this test, ACS shows us what resolve looks like. It reminds us that we are not powerless, that we are not alone. We are a community of lawyers, law students, scholars, and judges. People who understand what the rule of law means and why it matters. And that is why we stand firm in defending academic freedom and the free expression of students and faculty, because truth and learning are the bedrock of justice. We are troubled by efforts to penalize law firms and lawyers for the clients they represent or for their work to promote equal opportunity in the legal profession. And that is why we are unwavering in our support for judicial independence. Because when judges are threatened or lawful rulings ignored, the very fabric of our democracy begins to fray. Yes, the pace of these challenges can feel relentless. At times, the weight can feel heavy too. And it's okay to step back, to rest, to breathe. But we must not retreat. By being here today, by choosing engagement over silence, you're showing what courage looks like. You're showing up, not just for yourself, but for your communities, your clients, your students, and your country. This convention isn't only about diagnosing what's broken, it's about building together a constitutional vision rooted in being a force for good that improves lives. That was the same belief of the people who crossed the bridge at Selma. They believed in something bigger than themselves. They didn't wait for perfect conditions. They didn't wait for permission. They walked because they knew the future depends on those who are willing to act. Today, we face a different kind of bridge, one not made of steel or concrete, but of conscience. And like those who came before us, we must decide whether we, the people, will cross it, whether we will meet this moment with courage, community, and conviction. Democracy is not easy, but it is worth it. Thank you for joining this fight. Let's stand together because when we do, when we speak, organize, and lead together, we, the people, becomes not just a preamble, but a call to action. With that, I'll turn it over to Tainga Leslie, ACS's Director of Policy and Program for Racial Justice, who will moderate today's discussion, Resisting Oligarchy and Building Power.
Thank you so much, Roscoe, for those wonderful opening words. And thank you to everybody who joined our discussion today. A few housekeeping notes. Today's program will last for 90 minutes total. We're going to have an hour of panel discussion, and that'll be followed by 15 minutes of audience Q&A and 15 minutes in innovative talk packs where you'll have the chance to interact with our panelists and staff directly. So you can submit Q&A throughout the program at any time using the Q&A button at the bottom of your Zoom. Please make sure to use that and not the chat. As a reminder, this event is being recorded. And of course, we hope that you'll stick around for the talkbacks as well. Lastly, we do have CLE for this program. You'll need to submit 2 codes. I'm going to give you the first one now and the second one toward the end of the program. The first CLE code is Husky. And if you need help with CLE, you can always email us at convention@acslaw.org. Getting into the substance of today's program, we're here to talk about resisting oligarchy and building power because over the last few decades, we've seen the increasing concentration of economic power in the hands of a smaller and smaller wealthy elite. that's been turbocharged in this new Trump administration with the efforts of the Doge administration to gut essential programs, and even in the so-called big, beautiful bill that we know will cut essential services for the people who need them most. These are really dark and challenging times. There's no sugarcoating it. We've seen the rollout of the military to suppress protests, detention of elected progressive officials, and even assassinations in some states. And at times it can feel like even resisting takes all that we have. And that is why I am happy today to be welcoming people from the front line of the struggle. Our panelists today are lawyers who are using the law in creative and new ways, both to push back on oligarchy and in favor of working people, but also to think creatively about what it takes to build the future that we actually want. So the first person that we're going to hear from today is Ingrid Nava. She's Associate General Counsel at the SEIU, the Service Employees International Union, and she brings extensive experience in labor and employment with an emphasis on representing low-wage and immigrant workers. Ingrid, I'm turning to you because one of the biggest struggles over power we've seen in recent weeks has been about who even counts as a working person in America, with this wedge issue of immigration being used with workplace raids, those leading to the protests in LA, which have, of course, led to the federal repression, and even a president of the SEIU being arrested. And we see it more on a more casual level in this rhetoric of immigrants supposedly coming in and stealing jobs, this idea of immigration status as a divider among working people. So I'm curious to hear how you address this and go about this in your work and what it takes to build solidarity across immigration status in the workplace, and why do we need that if we're going to fight back on oligarchy?
Thank you. Thank you for inviting me and allowing me to speak. I want to open by saying that I think that labor unions are especially well positioned to build solidarity across immigration status. And as many people know, a core principle of the union movement is that an injury to one is an injury to all. And if you spend any time in labor, people who have, like me, spent their careers in labor know that that statement is not just a moral statement, it's a factual statement. Business gravitates to the cheapest and least problematic labor. So if there is one group of workers that can be exploited with impunity, it means that others are more likely to be replaced or shunned in favor of an exploitable workforce. And simply put, when the boss can get the same labor for less, 9 times out of 10, they're going to do it. And that harkens, made me think of another quote in the opening statement, that an injustice anywhere is a threat to justice everywhere, which is attributed to MLK Jr. In the current moment, when immigrants are being villainized, it's really imperative that unions respond. I think there's really 2 things that unions need to do in order to take advantage of their position. And the first is just to respond. It's imperative that they do so, even if response is imperfect, or you don't know how to message it all to your membership exactly, in the most beautiful way. It's important to send the message, I think, for unions that the well-being of immigrants is an important issue and it's a union issue. And then secondly, it's really important in my view, and where SEIU has been successful, and I'll talk a little bit about, is to involve members in the fight back. All good organizers know that people become invested in an issue when they themselves take action. It's why, on a union campaign, you will see organizers try to sticker people up or have them wear a button, because even a small action makes a difference in terms of people learning, by doing. And there are a few things that SEIU has been doing that I can highlight. One is that from the beginning of Trump 1, we've contextualized and provided an analysis to our staff and leadership. Lots of what's happening right now really was previewed by Project 2025. And really, since even before inauguration, we were trying to prepare people for what was to come. Explaining how illegalization could work, what the rhetoric of force multipliers meant, what that meant for our states in a lot of our sanctuary cities where SEIU is strongest, et cetera. And then we have continued to provide lots of training for union staff, so that when a worker comes into a grievance center, union staff on the ground know how to respond and address the immigration issues that are going to come up, and for staff that are working and organizing campaigns, so they know how to deal with the issues as people are starting to, either try to be re-verified or lose their TPS or other similar things, or face immigration law enforcement issues at their homes and in their communities. And we also had to think about how the immigration issues are going to come up in specific industries. We do represent workers who are graduate students. We represent workers in healthcare. We represent workers in schools. We represent workers who are janitors in commercial office buildings and elsewhere. And there are specific kinds of immigration issues that come up in those places, and our staff need to really know that and understand that in order to best respond. So we've been doing that as well. But also what we've done is involve members in actions. And we've done this not just in the current moment, but for most of my years in SEIU. Justice for Janitors, you mentioned David Huerta. He comes from the union in California that has janitorial membership. And Justice for Janitors since the 90s has been a campaign that is as much about immigrant worker justice as it is about just winning a union. And so we have been involved in that for a long time. In Trump 1, when many workers who were going to their check-ins were losing status at the check-ins, we took their sisters and brothers and sibling members with them to the check-in so that people could experience, provide them support, but also understand how they were being treated by ICE and by our immigration system in general. And that has continued. Ramos Ozturk, the Tufts graduate worker, is a member. We have had rallies for her, which educates members, not only provides solidarity opportunities, but educates members about due process issues. We've had rallies for other workers as well, Cleona and Llewellyn, whose last names I'm forgetting off the top of my head, but who had, even though they were green card holders, were denied admission back into the United States and detained and put in detention. And all of these actions, together really provide an opportunity for our union members, not only to stand together and to start to build a movement, to also deeply understand the ways that their, sibling union members are confronting injustice in the immigration system.
That is wonderful. It's wonderful to hear, and I am gonna want to go more deeply with you, but first I'm gonna bring in some of our other panelists so we can cover the ground, and then I'll come back in deeper.
Yeah, and we'll just say we also have had participated in amici and are thinking about lawsuits and that level as well, but we can talk about all of it.
It's a wonderful work. Thank you so much. We're also going to bring in, so we've seen immigration as one of the major factors changing federally, but we've also seen the firing of members of the NLRB, leading to the NLRB no longer having a quorum. That's the National Labor Review Board. And to speak to that, I'm going to bring in Marina Maltop, because she's a senior associate at Bernard, Eggleton, and Lavitt, and she's represented unions in front of the NLRB, but especially because they've represented Starbucks United, which was perceived to benefit in the last administration. If folks remember, when the term hot labor summer was being used from a more friendly NLRB. Now with the NLRB maybe not having a quorum or possibly even looking at a anti-union majority coming up, I'm just curious what the landscape is looking like for that kind of organizing of new unions, and how do your strategies shift in that environment?
Yeah, thank you so much for having me, and thank you for that question. And I'm really happy to be here with all the other panelists. Right, so Trump fired Gwen Wilcox, who was, maybe not so coincidentally, the only Black woman member of the National Labor Relations Board, leaving the board without a quorum. And that means that the board is unable to issue decisions or to take any actions as a board. That's especially important because it's probably old information for many of you, but labor law is somewhat unique in that it, through a series of Supreme Court decisions, has been interpreted to totally preempt almost all state and local action because Congress empowered the labor board to be the sort of exclusive enforcer, investigator, and administrator of the National Labor Relations Act. So if there's no board and there's no opportunity for state and local, governments to do anything, where are we? I'd like to kind of posit three ideas for where we go from here and how to shift legally, strategically, et cetera. So first, even though there's no labor board, meaning the multi-member board that sits in DC, there is still a National Labor Relations Agency, and that agency has regional offices throughout the country, and the agency is empowered through its general counsel to take a lot of actions that in terms of enforcing the National Labor Relations Act. So the agency is still conducting union elections. They are still certifying unions as the exclusive representative when workers vote to unionize. They're still investigating potential complaints of the act. They are still issuing complaints. Hearings are still happening in front of administrative law judges. So there's a lot still happening, with the caveat that things can change, and to the extent that the agency has always been underfunded. But so we can think strategically about what can still go forward under a no quorum agency and what can't, and shift our positions accordingly. So that's one thing. Second, I think we can be thinking a lot more about opportunities for state and local engagements. I want to say that there are some states, even under this preemption scheme, that have already been taking really creative and innovative approaches to protecting workers' rights, Minnesota chief among them. But there are new opportunities to think about preemption, because if the entire preemption scheme rests upon the idea that the board is enforcing labor law, but there's no board, is there still preemption? Ben Sachs wrote a great piece about this on labor that you can look to sort of outline the argument. And just today we saw New York State introduce legislation which would shift enforcement of labor law over private sector workers to their state labor agency. Now there's questions about whether or not that's preempted and whether that will pass, but there are opportunities to think creatively about whether state and local governments have a bigger role to play in protecting workplace democracy and workplace rights going forward. There are counter arguments, which I'm happy to get into later. Third and lastly, I just wanted to say that, labor is really no stranger to hostile administrations and hostile labor boards. Labor has operated under boards with no quorum before. It has operated under very anti-union boards and under very anti-union presidents. Unions, SEIU, has developed tactics to work in spite of those. We should remember those tactics, analyze what worked before, and apply those effectively today. And I also wanted to say that even under the best of times, meaning under the Biden board, a very pro-union president, a very pro-union board, a very pro-union general counsel, the fundamental flaws of labor law were still there and still, and so we shouldn't sugarcoat even a functioning board, because there were still so many things about it that hampered worker organizing. What I always come back to, and what I really learned from working on the Starbucks campaign, was that we have to focus worker power, and labor's power has always come from workers acting collectively. Labor's power has never come from the law and has never come from the state. It has existed in spite of those constraints. I think that when we fight, we win works no matter who we are fighting, as long as we are fighting together. And so especially as attacks on our comrades continue, I think we can recognize that collective and direct action is still our touchstone, and figuring out ways to make the law and legal landscape accommodate our collective action, and solidarity is the way to is the way forward.
I really appreciate that, and I think it's a kind of a helpful reframing to have at the beginning of of a conversation among lawyers about what the law can do. Also, understanding where power lies as well. Um, I want to, because you've alluded to Minnesota, um, go over there as well and talk and thinking about from the state power perspective what can be done. And for that, we're going to bring in Minnesota's Senator Jennifer McEwen. She serves as chair of the Labor, Finance, and Policy Committee in Minnesota. And Minnesota made major headlines in 2023 for passing what are considered some of the most progressive labor policies in the country. Before we start, I also want to acknowledge the recent assassinations and attempted assassinations of progressive lawmakers in Minnesota. We, of course, at ACS are very sorry about those and following those closely, and we appreciate you taking the time during this context.
Thanks, I appreciate that. Thanks very much for having me. Yeah, it's been a pretty scary week here in Minnesota, and a number of us specifically targeted by this right-wing, it seems to be a Christian nationalist right-wing person for assassination. So perilous times. My family was in hiding for the weekend, and I've never experienced something like that before. Me and my husband and 2 kids were at an undisclosed location under guard, and have just now been able to come home and are now installing security things at our house in a town where we usually didn't even lock our doors before. So it's been a lot. But thank you very much for having me. We have in Minnesota been able to make a number of really relatively significant, I think, for the United States, advances in labor law protections for Minnesota workers that we've been really proud of. I'll just sort of go through a quick short list of some of them. One of the big ones is that we passed a program to provide paid family and medical leave in Minnesota. That hasn't come into enforcement yet. It's at the turn of the next year it will. But this last year as well, we were able to push back against a number of efforts to either water that down or carve it up and make carve-outs. So that paid family and medical leave program is set to be a real game changer for Minnesota workers when it comes into force. We also passed an earned sick and safe time policy statewide for workers, and likewise had to do a lot of playing defense this last session and trying to prevent carve-outs of that, not only from sort of the right wing, but from the business community within the Democratic Party as well, who are trying to erode it. We also passed a program to provide unemployment insurance to school workers that are paid hourly. So a lot of our cafeteria workers, bus drivers, paras will be laid off at the end of a school year, and then we're specifically carved out of being able to receive unemployment benefits during the summer, which would lead a lot of people to leave, not come back. That just provided instability in their lives. So there's a huge amount of turnover, and it's also just based on a lot of historical prejudices that those workers have not been included in being able to access unemployment benefits. So while members of the trades, for example, might work seasonally, they can apply for and do apply for and receive unemployment benefits when they are laid off waiting for their next construction job. But these workers, largely women, disproportionately people of color, also were left out of being able to receive unemployment benefits. And in many ways, I think because the work that they do in our schools was just not taken seriously as the same kind of work. Has been viewed as a sort of second class work. So we were able to provide that, really happy to do that. And we held on to that also this last session. We also instituted a ban on non-compete agreements in employment contracts, and also fought really hard to have that not carved out again this year. Lots of attacks from the business community, bipartisan attacks, trying to make carve-outs to that non-compete ban that we enacted. And I'm sure most of us are aware of what a non-compete agreement is, where an employer is able to sort of in the paperwork that you sign when you start your employment, they might put a contract in front of you and say, well, if you leave, if you're laid off for any reason, if you're no longer employed with us, you can't enter into employment with anybody that could be construed as one of our competitors. So it really does limit workers' mobility and ability to be able to switch employers for various reasons. We heard actually recently, I had some people let us know through the union, Minnesota Nurses Association, that there are professionals who work in rural hospitals in northern Minnesota who provide reproductive care at one of the hospitals there, and wanted to do some sort of pro bono or low bono work providing reproductive care at a local clinic in addition, but they were barred from being able to do that by a non-compete agreement that they had signed on to previous to us enacting our ban. So that the effects of those non-compete agreements are having real tangible effects of harm on people being able to access reproductive care, for example, in rural areas of northern Minnesota. So we were really happy that we were able to hold on to that non-compete ban, and I think that we will anticipate seeing more attempts to carve that out next session. We passed a kind of a ban on captive audience meetings. Our governor, when he was running for vice president, sort of I think said some things about our captive audience meeting ban that were maybe beyond the scope of actually what the law does. Our law just prohibits retaliation for trying to coerce workers to come to a captive audience meeting. Of course, these are meetings where an employer, where there's a union drive or some talk about unionizing the workplace. Oftentimes we've seen this across the board. Employers will sort of coerce or require or seek retribution if an employee doesn't attend these meetings. You know, they might offer free pizza and some sodas and such, and then they have a anti-union lawyer, union busting lawyer come in and speak about all the fire and brimstone and terrible things that will happen if you actually get together with your comrades and organize and your colleagues and come together. So we banned the coercive aspect of that, or tried to, by prohibiting retaliation. We did a number of other things too. We could talk the whole hour about all the things we did. We're really proud of the work that we did. But one of the things that I wanted to make sure that people who are engaged in this type of work or who are interested in this type of work know is to reiterate something that was said by the previous guest. And that is that in my experience as an attorney and now as a legislator, the real power and the real action that happened in Minnesota are protections that we were able to provide and enforce through the law. They didn't come because of the law. They didn't come because legislators at the Capitol just have this really pro-labor view. They came because of tremendous labor organizing within the state of Minnesota over decades. So workers in Minnesota, Minnesotans, working together with their coworkers, within their workplaces, with their unions in community, over time, putting together their list of demands, and then luckily electing legislators who had enough ties and connections to that movement work that we were going to go in, if we were elected, and institute that list of demands to the best of our ability, and that's what we did. But it wasn't because of just some beneficent lawmaker goodwill or the law being in a place. The law follows the work that the people are doing. So the people did the work, the people made the demands. Then the people elected the people to institute the work that they had done and carry that into the law to support them in the work that they were doing. That's really where the work is. So it is one of the interesting things that I thought about when I was invited to this to share on this panel is this idea of resisting oligarchy is interesting to me because I feel like it comes a little late. Sorry to everybody, but we live in an oligarchy. It's already here. It's been here for a really long time now. And what we're doing, I think, in the work that I'm involved in is trying to sort of claw back some semblance of space where we can begin to exercise democracy within that oligarchy and to try to push back on an existing entrenched oligarchy. So yeah, a lot to say. I look forward to the discussion, but maybe that will be a good start anyway. Thanks very much.
A wonderful starting point. Really, thank you so much for the work you're doing, continuing to do, and for also lifting up all those people who made it possible. Our fourth panelist is actually kind of moving toward those hinterlands beyond the law, because our panelists so far have talked about, existing legal structures that allow for unions to the extent they do, or creating new law. But we've also got Professor Greg Baltz, who is at Rutgers Law School, where he directs their clinic on housing justice and tenant solidarity. And he's been working on tenant unions, which are a newer form of organizing, not yet completely recognized with the law, but that people are nevertheless using to build economic power, win resources back from landlords. So I'd love to pass it to you, Greg, to first lay out a little bit of what tenant unions are doing and how they're working, and also how the model works when there's so little legal scaffolding to support it.
Thank you so much for having me and for giving me a chance to talk about tenant organizing alongside labor organizing. Both are arenas where people confront concentrated power. In the workplace, it's the boss. In housing, it's the landlord, but often they're backed by lenders, investors, developers, and government. And both are arenas where, through collective action, organized members can actually exercise material leverage against their opponents. For workers, that's walking out on the job and withholding their labor. And for tenants, it is staying put in their apartments and refusing to pay their rent. And so, to your question, what has tenant organizing achieved, even without this legal scaffolding? The answer is quite a lot, though it looks very different across jurisdictions. And it also looks pretty different from the types of victories we've seen from labor unions. The tenant movement's been going through a resurgence since the foreclosure crisis and Occupy Wall Street. There's been an explosion in what some people are calling tenant consciousness. This idea that people should identify and can identify as tenants as a political identity, in addition to as workers or based on their identity. If you look at cities like New York, Los Angeles, Boston, Kansas City, but also Louisville, Kentucky, Bozeman, Montana, tenant unions have been able to win or are fighting for things like rent control expansion, eviction moratorium, just cause eviction protections, tenant right to counsel legislation, and just as importantly, they've blocked individual evictions physically with their bodies, forced landlords to make repairs, and in some cases, even negotiated collective bargaining agreements. Just 2 weeks ago, Kansas City tenants announced that they had, following a 247-day rent strike, secured a collective bargaining agreement. These are substantial wins, but they're often happening outside of formal legal processes, which I think brings me to the second part of your question, which is, what does it mean for these groups, these tenant unions, to organize in the shadow of the law? It means acting in a terrain where the law is largely silent as to tenant unions specifically, but the law still deeply informs these group strategies. Tenant unions don't have the same statutory protections that labor unions do under the National Labor Relations Act, flawed as some of the speakers have already mentioned those protections are. There's no equivalent of the National Tenant Relations Board. A few states, but Minnesota is one of the exceptions, have a guaranteed right for tenants to organize. And only 2 cities, San Francisco and Berkeley, guarantee the right of tenants to bargain collectively with a landlord. So instead of relying on these legal frameworks, tenant organizers build power without formal legal recognition. This looks like direct action, eviction blockades, rent strikes, public shaming, coalition building, and leveraging media attention. The lack of a formal legal structure also enables tenant unions to be flexible. No federal legislation means no federal preemption. Any two tenants in a room can be a tenant union. No administrative board signs off on an election. A bargaining unit can be defined however those tenants choose. It can be tenants all living in the same building with a common landlord, but it can also be tenants spread out across the city, living in smaller properties with different landlords. There's no comprehensive legal framework, but that doesn't mean that there isn't tenant union law. Laws that relate to tenants' right to a renewal lease, rent caps, the ability to withhold rent, all play into the bigger picture of the strategies that tenant unions use, as well as larger scale policies like rent control and land use decisions around who gets to develop where. That's what it means to organize in the shadow of the law, to treat the law not as the boundary of what's possible, but as one tool in a broader political and strategic toolkit. Tenant unions aren't waiting for a law for permission to act. They assert their rights that don't yet exist, and sometimes through that process, make them real. So organizing in the shadow of the law is both a constraint and an opportunity. It's where people invent new forms of solidarity, where legal rights are not handed down, but fought for collectively from below.
Very interesting. And I'm almost surprised by having a panel, an ACS panel with all four of you expressing some degree of skepticism, or at least seeing the law as just one part of it. I'm curious, as far as your work goes, what other tools are you drawing on at this time? As you see the limits of the law, what other tools are you drawing on? And especially, for emerging lawyers or even lawyers who are, looking to expand their skill set, what kinds of skills do you think we need in this moment?
Is that to me?
Sure, I want to hear from all of you, but you go for it, Greg.
Sorry. Okay, so one thing I do want to say, because I teach a clinic supporting students who want to be movement lawyers, is that the most important thing you can learn how to do is be a good lawyer. That is the reason why organizers and members want you to be in the room. So anything else I'm about to say is still premised on the idea that you have to be able to do a good job for them in court. But I do think, especially now, it's important for students and lawyers to understand how organizing works as a skill set, not as a kind of romantic thing from the past that has the capacity to create change, but literally what is it that an organizer is doing? Because that's, so for example, I, as an attorney, might not want somebody to speak at a rally I'm scared they're going to say something that's going to undercut their testimony in court. But an organizer is seeing that opportunity for them to speak as an opportunity for them to develop as a leader and to take on more responsibility and put their face out there in front of the cameras, like Ingrid was talking about. You have to understand why organizers are doing what they're doing to collaborate with them well. And so I'll just say there are many ways to do this. You can get involved with your graduate student union. You can get involved with your AAUP chapter. But also, if you're just a nerd like me, you can pick up Jane McAlevy's No Shortcuts. No book is cited more by organizers in Zoom meetings or at public meetings than that book. So definitely check it out.
I actually want to go over to Ingrid because I know she has a background as an organizer as well, but one interesting thing that SEIU has also been doing is trying to expand union presence in the South, and that's an area of the country that has really tried to build a legal infrastructure that's not very pro-organizing. I'm curious about what strategies look like there, and what were you experimenting with to try to move through those kinds of landscapes?
So a lot of different things, but there is a project of SEIU called United Southern Service Workers, which is a broad organizing campaign, and what it is primarily engaged in right now is identifying people and mobilizing people around their workplace issues. There's not an immediate right now attempt to try to drive towards collective bargaining rights for any particular group of workers, but to start to build up a cadre, so to speak, of workers that can learn how to build together and raise their voice and learn what their rights are and go from there. And so as a result of that, there have been some wage and hour issues that workers have addressed, for example, at some Waffle Houses, and some other dollar store, similar kinds of issues at workers who work at dollar stores. But SEIU is invested in this, even though there's not a short-term, get to collective bargaining and get regular dues base, because we know that we need to build up on the ground over a longer term to begin to have the power that we need to make change in the South. But apart from that, there's also in some settings, it's a little bit easier to organize. So for example, we have a nationwide airport worker organizing effort. We represent already, I think, close to 40,000 members across the airports of the United States. And the people that I'm talking about are service workers. So they are often the people who put bags on the conveyor belt and who wheelchair folks around the airport and clean the airplane cabins in between flights and that sort of thing. Because we already represent lots of those workers across the country, and the employers tend to be the same, even if they're in the South versus if they're in O'Hare or LAX or JFK, we can engage in organizing in a little bit of a more robust way in those places because we already know the employer. And in some cases, we've already won and are able to leverage our relationship elsewhere. So there are direct, organizing campaigns going on, particularly right now in DFW and at Charlotte Airport, and also at Phoenix, which is Southwest.
Thank you. And very exciting to think about like that, untapped base of folks who may want to get involved. I also want to turn it to Marina because it seems Starbucks has been part of this, or in my mind, is part of this like wave of sort of the new economy companies, like these very 2000s companies, Amazon, some of the others that have really pushed back very hard on the idea of worker organizing and also of the idea of organizing being relevant to the way that people want to work or will work in our new time. And so I'm just curious I'd love to hear your thoughts about like, okay, what does it mean to actually make real gains in those spaces, and what kinds of wins have you seen?
Yeah, starting with your premise, I think the conventional wisdom was that a company like Starbucks couldn't be organized for many reasons. There's so much worker turnover. There's so many so many stores. The units are really small. Service sector restaurant workers are, just by the numbers, very unorganized. So one thing to learn is just we're in a different playing field today, and conventional wisdom can only get us so far. And I think, just speaking personally, that the union did an incredible job of seeing where the energy is and where worker organization and power and excitement came from, and then fueled it, right? This was a campaign that started from the workers, and really from the just unbelievable way they were treated during the pandemic. I think that was a really big sparking factor. And so these are really small shops. They have, a lot of times the workers are working very closely together. And it just took off like wildfire. And I have to say that, Starbucks workers, generally speaking, the ones that I know are some of the most bravest, funniest, most caring, hardworking people that I've met, and their ability to harness social media in a totally organic way to get the message out there and to recruit other stores to the cause was incredible. And then I think, one thing that I've learned as a lawyer on this campaign is that even if you represent a union, you have to know a ton of different types of law, or you have to learn them really fast to be effective. Through the Starbucks campaign, I had to learn about, property law, about protests and strikes, and where we can stand and where we can't stand, some criminal law about potential like civil disobedience actions. I had to dust up on that one corporate law class I took in law school, learn about shareholder structures and things like that. So the ability to sort of twist and turn and to kind of just learn what you need to support the union is a good skill to have. And finally, just both the workers and the union, I think, really did an incredible job at leveraging the public campaign in the Starbucks campaign, because Starbucks, put itself out as this very pro-union, very millennial, very, progressive company that treated its workers so well. And so the fact that the workers were able to pick up on that dissonance and use that to pressure the company to treat its workers better, to recognize the union, to come to the bargaining table is that's a tactic that unions can use in various legal and administrative environments. So I think that was also a really effective tool.
To Senator McEwen, in some ways, legislation feels like the accomplishment, just the way we're taught in law school, and it arrived and landmark legislation is here. And yet implementation and how it actually rolls out is such a big part of it, and often, more important for the ultimate impact. I'm curious if you could speak to that, what have you seen so far in implementation and getting these things to actual impact, and also how do you keep folks engaged and really see that, so it's not just, okay, well, it was legislation, it went away, became bureaucratic, and sort of loses that connection to the people it's trying to serve.
Yeah, I really think, at least here in Minnesota, what we have seen is it just goes again to that importance of the organizing on the ground by labor of the various unions across our state. They have remained engaged during this period of implementation. And so we passed this whole series of landmark labor law reforms and improvements in Minnesota in 2022 and 23 was the big year, I think. But this last session, there was a concerted effort from our Chamber of Commerce, which is really bankrolled by the big players in Minnesota, like 3M, Target, really large powerful corporate entities, to come at all of that legislation, and in particular, the big, meaningful pieces of legislation. So they really tried to come after earned sick and safe time, really tried to come after paid family medical leave, tried to come after those non-competes, and really tried to spin a narrative of like the pendulum had swung too far toward worker protections. Sort of like we heard a lot of this in our Senate Labor Committee as well, especially from some of my Republican colleagues, where they were sort of bemoaning, like, oh, it's so hard to be a business owner in Minnesota. It's just so hard. There's so many mandates, there's so many rules, and it's so hard. And if you break that down, what they were actually talking about is, it's really hard to give 1 hour of earned sick and safe time for every 30 hours worked. Like they were trying to make this sort of argument that the rules, they would say, well, most employers are doing these things anyway, but then they would sort of on the other side of their mouth say, but these rules are so hard to follow. But what I guess what I wanted to, coming back to your question about the implementation period, it would have been perhaps impossible for us to hold the line in protecting those pieces of legislation that we enacted that are being now, some of them already have been implemented, but there's some rulemaking going on within our, labor and industry department and in the Department of Commerce. There's different departments that are making rules and making sure that are actively doing the implementation like right now in real time. It would have been impossible for us to hold the line as legislators, I think, at least with the political makeup in our Minnesota Senate is 34. It's Democratic farmer labor in Minnesota. We're very proud of that history. It's not just Democrats, but there's Democrats, we have 34, and Republicans, we have 33. And all of the Republican caucus in the Senate was very united behind taking carve-outs of all of those pieces of legislation. And so for us to be able to hold that line of those 34 votes, not allowing carve-outs and changes to those pieces of legislation, the only way that we were really able to do that and allow that implementation to continue by our agencies is because of the power of organized labor. That is it. That is the power. I mean, it is in the moments of where a bill would come up in committee and it might start to get some legs and start to move to make these carve-outs, labor was activated. And so you had the network of unions across the state activating their membership, making calls, literally physically showing up at the Capitol, scheduling meetings with legislators, and just really saying, don't change this stuff. This is stuff that we invested in. We want to see it implemented. And without that, I do not believe that there is enough like political courage from legislators themselves to just hold the line. It really needs the backup of like a movement of people kind of holding elected officials accountable to that movement and to the work done by the movement.
That makes sense. We're gonna get into a few more of these questions submitted via Q&A. So if you've been holding on to those, please do submit those. It's the box with the question on it at the bottom of your screen. But I'll go ahead and direct the first one to Greg. And this is about how we've become a litigious society and the legal system has become such a dominant force generally, especially since the civil rights movement, this person points out. And would love to hear more on this power issue, especially as as lawyers try to engage with movements, but even as you think about teaching the law, how do we kind of address that and move away from that? Because this commenter is pointing out there can be that form of oligarchy as well.
Yeah, it's interesting. I don't appear in federal courts that often. Most of the time when I'm representing tenant union members, I am in a state trial court, oftentimes a state trial court with circumscribed procedural rules that allow a landlord to evict somebody within 14 to 30 days. And that was the case. My clients were getting evicted before January 20th, and 4% of tenants in New Jersey have attorneys, while 90% of landlords have attorneys. So we might be in too litigious of a society, but there's not that much I can do about that other than fighting for the people who are in front of me to be able to stay in their homes longer so they can carry out the fight that they're in. There's just a dramatic power imbalance in the court system. And I don't think that necessarily more lawyers or the law are going to alter that framework. I think that that framework is empowered by those who have created it, but it doesn't mean that we can't use it. Like any good defense attorney in any civil context, their job, in part, within the bounds of ethics, is to make that proceeding longer and more expensive while they let the other dynamics work out. And in the context of traditional civil litigation, those costs impact settlement. In the context of organizing, timelines create space for the creative work that you've heard described here today. And so sometimes that also means using the court system against itself within the bound of ethics when it is inefficient, when it is bloated. I got my start as a tenant lawyer, student attorney, representing every single foreclosed on homeowner we could find in the city of Boston, to go through 2 landlord tenant judges in that city to basically glue up evictions by filing the answers and jury demands in every case, as were those tenants and homeowners' due process rights. And that created time for organizing. So we have to think, given the description of the system, we have to think creatively how to use it to improve it, but also sometimes against itself for these greater movement wins.
That's a very, the idea of like, using this process to slow things down is very interesting. And it kind of makes me think as well. I'm curious about Ingrid's work because we have a very clear federal agenda, at least in regards to what they want to do to all immigrant workers in this country, right? And so I'm curious your strategies as to gumming up and resisting that when sort of the overall goal is so clear. But before you answer, I'm being reminded to give the second CLE code, which is COLLIE, COLLIE. COLLIE, and now over to you, Ingrid.
Okay, so you're asking me about how to slow things down, or how to use the system in a way that immigrant workers. Is that the question?
That's right.
Well, I mean, I think that I don't do direct immigration representation of the worker. So for example, if they have to be represented in immigration court, or they're filing an appeal on their immigration issue to federal court as an individual, that isn't something that I, as the union lawyer, do, because the union is my client rather than the individual. But it is certainly true that that process is a big part of what we want to protect in general for workers and for immigrant workers, and that means that it takes a long time. Sometimes, for example, asylum cases can take a decade in many cases, but in order for the persons to be able to show all of the evidence necessary to show that they do in fact have a credible fear on one of the protected bases, it takes some time to accumulate the evidence and to be able to present it. And given the number of people that are in the system, all of that can take a very long time. And in fact, there not being enough also immigration judges in a lot of cases. And so the process, what I would say is that the process is important, because we don't want to rip that away and shortchange the ability of those people to be able to really present their case. So I don't know if it's so much as using delay as it is making sure that people have all of the process that they should be getting. That's the way I think about it.
That makes sense. And it's I wonder if I think about that with like the Remesia case and some of these other cases that we're seeing where there's just no process at all.
Right.
Yeah.
Well, in a lot of to the question that was put in the chat regarding immigration, like why it's important to deport people who are not supposed to be here, and that there are additional comments. There's not discussion about poor Americans who can't get into the workforce due to structural discrimination. I would say a couple of things. One is there's no reason to believe that mass deportations are going to be, there's no structural discrimination in getting into the workforce. I mean, that's not, mass deportation isn't going to lead to the dismantling of structural discrimination. It's just another form of it. And what the current administration is doing, to the point about Rumesa and a couple of other members that I mentioned, what we're seeing right now is not that people are being, there are people who are deported, I think in some cases, that are undocumented. But there are many people who are losing their permission to be here. All of the people that I mentioned, 2 of them have green cards. They were given permanent residency in the United States. And that was being ripped away from them. It's now being challenged. They're out of detention, thankfully. And Rumeysa is somebody who also had permission to be here and study. And, apparently the only, charge against her being that she wrote an op-ed, which is supposed to be protected speech. So what is happening is not right now deporting people who are not supposed to be here. It's much darker than that. And then I would say finally, to the question of there are undocumented immigrants in the United States, certainly, and many of whom are, I think most of whom are in our workforce. The issue in large part is that we have not had comprehensive immigration reform over the last 2 decades, when we should have had it, to be able to manage the inflows of people who want to come into the country. And I do believe that people should be able to come into the country relatively freely, because if capital can go anywhere in the United States and set up shop and try to globally drive down wages, then workers need to be able to cross borders as well and exercise their rights in all portions of the globe.
I really appreciate you tackling that question. And I also want to see from Jen's perspective, I think when crafting almost any social welfare law, there's often this pressure to put carve-outs about status and who will be allowed to partake of it. And I'm curious if that came up in the context of Minnesota, how you approach that conversation, and some of these concerns that were raised in that comment about, okay, the most marginal workers here and who's going to lose out to other people.
Yeah, it has come up most recently. Unfortunately, in my view, the leadership, both of the Minnesota Senate, which is a DFL leader, the leadership of the Minnesota House DFL, who was just murdered, and the leadership of the Minnesota Republican House, because they're tied in the House, the Democrats and the Republicans, and then our governor. That leadership made a deal for people that don't follow Minnesota politics intimately wouldn't know this, but we finished our session and had to adjourn, but we hadn't passed all of our budget bills yet. We weren't done. We were sort of locked in conflict. And so we went into a special session just, I think, about a week or 2 ago now. But the leadership made a deal, and I don't know, because I wasn't in the room, all of the different nuances of how the deal came about. But the deal involved removing eligibility for undocumented adults to be able to access what is our Minnesota Care program. So it's a publicly subsidized, you still have to pay for it. It's by income, but health insurance to be able to access health care. And our posse caucus in both the Senate and the House and allies tried to sort of rebel against that deal that they made when we found out about what the deal was. But they traded out, that's what they traded out. They traded out healthcare access for undocumented adults for preserving some of the other wins that we had made in the last couple of years. So it was a really, it was a dirty deal. And like a lot of people who pointed out the harmfulness of that deal, really, had excellent examples that they brought forward of, these were their family members. Many people who've been here in our communities. Many have U.S. citizen children, family members are married, even, there's lots of involved people that are integral parts of our communities. Some who have, a cancer diagnosis, or they're getting dialysis, or they're getting really important medical care that is keeping them alive. Those people will have their health care cut off now because of the bargain that was made in Minnesota. So yeah, it's horrible. And we're sort of braced also for some of the cuts that we anticipate coming from the federal level to Medicaid, and just how far reaching those are going to be and affect our own state budget and our ability to deliver services and healthcare and social services, the whole gamut of things. It could destroy a lot of our budget here in Minnesota. So we're going to be we will be in a situation, and with education things too. I mean, depending on what the right wing controlled federal government, if they come in making demands where we have to, pass a law not allowing healthcare for transgender people, or we have to pass a law, like how many things are they going to condition on making sure the federal resources come back into our state? And those are decisions that then we'll have to make as elected leaders. Are we going to give in to the bullying from fascists at the federal level and at the state level, and do away with people's human rights in order to keep the money flowing for essential things? Or are we going to draw a line and say, well, we're all in this together, and we're going to take whatever hits come to us together? That's my preference. But these are debates that are happening in Minnesota, certainly, and we just saw, a terrible example of that coming into real relief. So these are, anytime you have fascism rising up like this and demanding that rights be removed from people in order to just have basic government functions continue, it's terrible. We're in a really rough space. I think we just don't know what's going to happen.
We're coming near the end, but I want to give Marina also a chance to comment on that, because we have another Q&A about this idea of workers and immigrants protections, and I'm curious if that's come up in your context of organizing. And then one that I hope everyone can at least give like a one-word answer on is just, what can our audience do? You've got 80 plus folks online who want to get involved and want to think about what they can do. So if you can do a quick one, and then I'll hopefully get a round robin to all of you.
Definitely. One thing that is, farm workers and agricultural workers are excluded from coverage under the National Labor Relations Act. That it stems from kind of our from our racist history as a country, and specifically the history of enslavement in this country. And so that is sort of a stain on our labor law. And it is also, like here in Washington, we have a little Norris-LaGuardia Act that offers protections to farm workers. So there are ways to, so again, we can think, broadly and creatively about whether there are legal avenues to protecting immigrants, people who are documented or undocumented, not just, under the black letter labor law. So that's something that we're trying to do creatively here. And in terms of, what we can do as lawyers, I have two thoughts. One, this is sort of specific, but lawyers write a lot. Like we do a lot of writing, and for people that don't write in their everyday lives, writing can be sort of like a intimidating, or kind of like, oh, I can't do that process. Helping people to write op-eds, to kind of get voices out there, I think is a really good, that's been a strategy that I've tried to use, and I think that's been really effective and fun, and a creative endeavor that you can take with people. The other thing is, I just think being a lawyer that shows up to rallies, to strikes, to being someone who kind of puts your body on the line along with other people, can be helpful. I mean, one, because it's the best part of the job, like by far, and you need that that burst of people power to get through the day sometimes. And also because when you're, I think like, not to, but I think when your lawyer shows up to the strike, you just feel maybe a little more empowered, and for better or worse. But I think that's for better. So those are two things that I would encourage all of us to do.
Interesting. I lied. What we're gonna do is we're gonna keep talking, I hope, about ways that we can all get involved, but we will keep doing that in our talkbacks. So I hope that folks will stay around for those. You'll get a more intimate space to talk with the panelists and some ACS staffers, and talk live. And in a few moments, we'll get those set up. So you're just gonna wait for there's going to be a button that's going to appear on your screen. We're going to assign everybody to a breakout group, and then we'll roll over into those groups. So that should only take a minute or two to get set up. In the meantime, we really thank all of you who came to this part, our panelists. Next week is going to be our panel on Then They Came for Me, Protecting Our Neighbors and Ourselves. And we're going to be continuing to dive into the immigrant issue, as well as the rise of fascism and how those intersect. And my lovely colleague, Valerie Nannery, will be hosting that. So I hope you see that next week, Wednesday, the 25th at 2 p.m. Otherwise, I'll see you in the talkbacks.